I'm a professional editor and I've always wanted to expand my horizons by talking to other editors and sound designers, music composers, visual effects supervisors, essentially all the magicians who silently and invisibly work behind the scenes. This series is an attempt to make the invisible artists visible. I hope you enjoy the conversations. Hi, and welcome to The Finest Cut. I have with me today advocate Anamika Jha. She's a media and entertainment lawyer, and she's a founder of Attorney for Creators. So, very glad to have you here with us, Anamika. Thank you for giving up your Sunday morning for us.
It is absolutely pleasure, Antara, to be with you here. Thank you for inviting me.
Absolutely, absolutely. Anamika, I'm going to jump right into the questions without taking up too much of your time. And I wanted to start with asking you something that I read on your blog. You say that there's a dichotomy between art and law. Can you just explain this a bit more?
Why I said it, actually there is two ways. One is like art and law, both are inseparable because law is inseparable aspect of anything. Whether we live, whether we pay tax, whether we do whatever commerce and anything, any business and everything. But when it comes to the art, of course, there is law. It is regulated, but it is not in India. It is not highly regulated field. Okay, so most of the regulation happens through the contract, and generally artists do not sign agreement, and they may not be aware of their legal rights. So when there is an unawareness regarding law, when you are not highly, formal industry, so there starts the dichotomy. So from my meaning or analysis to dichotomy is that although there is the presence of law, although everything is highly regulated, but when you are unaware, when you don't sign the agreement, then the dichotomy starts.
Right. So since you said, and you're aware that a lot of us in post-production particularly don't end up signing contracts, Anamika, why is it important to sign a contract in the first place?
Yeah. So yes, it is a very good question, very basic question, but it is a good question. Look, not just in the post-production stage. Whatever my experience has been, people don't even sign in the pre-production, during production, generally because in our industry, there is the practice of, word of mouth kind of thing or verbal kind of thing. We trust each other when we work in industry. And this we avoid that why to go and get into that legal documentation and all. It is time consuming. So let's without signing the agreement, let's proceed because we know each other. Nobody is going to harm. But that is a problem. And second problem is that sometimes you feel yourself so intimidated. You feel yourself having such a low bargaining power that you think kaam to mil raha hai na, let's not sign the agreement. Get the work first. Yeah. And if I will be start getting work, agreement sab ho jayega. So this kind of, led by, you can say, having less bargaining power or having this kind of practice in the industry, people avoid signing agreement. But also I want to add here that now the things are changing. Now, even if the people, like most of the big production houses and all, they have to be very formal. So they make you sign agreement. Similarly, I have seen awareness among the creators as well, that they also insist on the signing agreement. That's why we are having this conversation right now, because you being an artist, have this kind of, awareness that you want to know about it, and therefore you have invited. So this kind of awareness I can see, which is a good thing.
Great. And it really resonates with me, all of what you've said just now, because these are things that we are kind of starting to think about, and we don't have the right understanding of something, even as basic as, so I know we have labor laws in India, but are these labor laws applicable to the film industry?
Labor law is applicable to everyone, correct? So we do not have a separate set of law for film industry. So film industry also being an industry should be governed by the labor law. Now, labor law is generally in India focused on the employer-employee relationship. Okay, so when you work in a corporate house, there is a strict applicability of labor law. There will be certain PF deduction, there will be certain health insurance scheme, and everything. These all aspects comes under the labor law. So suppose you work as a writer, suppose you work as a staff writer in a production house, then of course, or you work as a staff creator in a production house, so of course you are going to come under the ambient of legal labor law. But generally, if you work as a freelancer or if you work as a service provider, in that case your only recourse is your agreement. You are not protected anything except or outside that agreement. So labor law is applicable, but it will be applicable when there is an employer-employer relationship.
Since the labor laws apply differently or don't apply at all to the freelancer, as you're saying, there'll be a vast difference between an employee's contract and a freelancer's contract, right?
Mm-hmm, mm-hmm. Yes. So yes, there is generally what happens in the case of employee, there is always a fixed set of agreement. Okay, you shall receive certain money. You need to give certain notice period when you are exiting. These are the common clauses. This will be your salary, this will be your benefits and everything. And that is more or less fair only because all of the employee, and it is since it is regulated as well, that you need to give your, you cannot say contractually that I shall not give my employee maternity leave. Okay. Or you have to work during your maternity period as well. You cannot say that because this is a regulatory mandate that you need to give your employee a maternity leave. Or if there is a certain public holiday, if there is a certain holiday, of course, we work on holidays as well in the company and all, but there is other concept like overpay concept or something. So there are all those regulations are there in the place. There is a certain leave. You need to give certain number of leaves to your employee every year. And that you cannot deny by employment contract. So this is more due to being regulated. It is more or less fair, okay, in employee contract. I haven't seen generally, of course, there are some disputes, but generally it is smooth when you are working as an employee to certain industry, a certain company. Okay. Now coming back to retainer. Here it is not, there is certain, there is no legal statute which say that you need to give your retainer this benefit. You need to give your retainer this. Means you do not have to have certain compliances. This is a clear bargaining case. Like when I work as a retainer, I shall negotiate my contract. Look, I want this benefit. I'm providing you this service. So everything is under that agreement only. So when you have a lower bargaining power in case of signing a retainership agreement, then you can face, discrimination. Not discrimination, right word. Arbitrariness is the right word.
Yeah.
You may face that arbitrariness. Yeah.
Yeah. So Anamika, to understand now, we are given all these various things to sign. We get NDAs. Then sometimes they say, oh, assistants, we don't need to give them agreements. We give them an MOU. And then they say that for, professionals, the head of departments, we give you LFAs. So can we break down what is an NDA, what is an MOU, what's an LFA?
Yeah. So basically, all this comes under a big umbrella of agreement. Okay. So may it be NDA, LFA, MOU, term sheet, everything comes under the agreement only. But the nature differentiates due to the nature of its work. Okay. NDA is suppose one party is sharing some confidential information with you. Okay. And they say that you are not allowed to disclose this information to anyone. And you shall use this information only for the purpose due to which we have, disclosed this information. For example, a writer is hired by a production house. They give them a certain concept. They have to develop, suppose, a Bible. And after developing that Bible, now they may hire other writer for the script writing or something. But they have given you all this information, right? Their concept, suppose it is based on some other literary work, then they shall provide you those literary work, research material, everything.
Yeah.
Then they shall make you sign an NDA, non-disclosure agreement, that you shall not disclose this information, whatever I have disclosed to you, to any third party. Okay. Yeah. So that is NDA. Ideally, when a writer approaches a production house with their own concept, then production house should sign an NDA because they have pitched it. Now they have their confidential information, and they should not reveal this to any third party. So ideally in that case also a production house should sign an NDA. So that is a non-disclosure agreement. Now coming to the difference between MOU and agreement, you say. So I said agreement is a set, MOU comes like a subset. Suppose you don't want to get into a very detailed agreement, okay? You just want certain basic understanding. For example, you are a writer and you have a friend who wants to direct the film. Okay, whatever you write, he or she is going to direct it. You both brainstorm, you both make, he or she gives her vision regarding the project. You being the writer, write it down. So both of you are working together. Right now, there's no production house or someone on board. Then there should be some document which decides the relationship between you and your friend, the director, you being the writer and director. So here, you at this stage, you don't want to enter into a very detailed agreement, okay? Maybe due to your finance, maybe you don't want to spend that much of time, but you want to keep the rights clear. For example, you are the writer. So whenever the project will be, pitched to anybody, I shall give the exclusive credit and money for the writer. Similarly, director will think writer can, break away from me and go with any other director because writer has the IPR. So then writers will put it in the MOU that, look, you cannot go to any other person without me. We are collaborating together and we shall work together till end. And we will negotiate the remuneration credit with the producer. So all this understanding is required to be captured in a small kind of, a basic agreement. So MOU is full formed as Memorandum of Understanding. Means the basic understanding, which is binding between me and you, can be capsulated into, and I think it should be encouraged. MOU should be highly encouraged because it is not that tough. It is well legally drafted document which you can sign so that everything remains clear. Tomorrow you will not face any kind of problem कि किसके पास कौन सा right है, क्या होगा, मेरे project का क्या होगा, मेरे credit का क्या होगा, मेरे पैसे का क्या होगा. All these things will be included in that. So this is a very helpful document I'm giving it emphasis here because it is very helpful document for all the artists or small directors or two writers collaborating together as a collaborator, or even you being the editor. Suppose you guys have created a project together. Now you want to, bring some bigger production on board, but you want to edit and make the project proper, visible. Even in that case, you guys can sign an MOU. So that is MOU. Now coming to LFA, long form agreement. Okay. Yeah. So what happens? This is when you are entering into some complex arrangement. Okay. So suppose you are co-producing a film. Okay. So at this stage, you are at a very beginning stage. So in the beginning stage, you sign a term sheet, okay, that captures the basic understanding between you all, like all the co-producers. I'm just giving you an example. It doesn't mean that co-producer will only sign the term sheet. I'm saying any person who is entering into a complex transaction will first sign the term sheet. Now money keeps coming, project starts, becoming more visible. Now the things are more planned. In that stage, you sign a long form agreement, okay, which captures everything because here it is very complex. IP creation is here, roles and responsibilities are here, the detail, how the film will be distributed, what will be my revenue percentage and everything. A lot of them comes there. So then all this will be covered in the long form agreement. अब long form agreement sign करने में कम से कम महीने 2 महीने लग जाते हैं. तो why to waste that much time? तो start करने से पहले हम उसमें फंसे तो इससे अच्छा लोग क्या करते हैं, टर्म से साइन कर लेते हैं. भाई सारा इन्फॉर्मेशन जो बेसिक अंडरस्टैंडिंग कवर हो गई, हमने साइन कर लिया. अब हम काम कर रहे हैं और एक सर्टेन स्टेज हम सर्टेन टाइम ले लेते हैं कि भाई 45 दिन बाद 60 दिन बाद फिर हम लॉन्ग फॉर्म साइन कर लेंगे. तो इट सिक्योर्स योर राइट बाय टर्म से and gives you ample of time कि अच्छे से डिस्कस करके लॉन्ग फॉर्म अग्रीमेंट साइन करें. तो दिस इज लॉन्ग फॉर्म अग्रीमेंट.
राइट. That's very helpful. Thank you so much, Anamika, because this is, I think, something that not a lot of people are aware of. Yeah. And I'm very interested in what you said about the MOU being such a important document. That's a perspective for us to think about, actually. Right. The other thing I wanted to ask you is कि कई बार ऐसा मेरे साथ भी हो चुका है that some production houses will not make you sign the LFA on stamp paper. वो लोग लेटर हेड पे dal ke, then they expect you to sign. Now, when I ran into trouble with the production house over payments, and I inquired, this is back in like, I think almost 8 years back or so. I was told that agreements signed on letterheads are not legally admissible. Is that true?
Okay. So look, stamping is a different aspect and signing agreement is a different aspect. Okay? Agreement is governed under Indian Contract Act. Okay? And stamping is governed under Indian Stamp Act. Two different regulations. Now, when you sign an agreement, even on the letterhead, if that agreement has been signed by free consent, if there is a lawful purpose, lawful object, there is there's proper consideration exchange. If all these elements are, satisfied, then an agreement is legally valid. But if you don't pay the stamp, suppose as per your agreement, you should pay the stamp. That is a legal mandate. And if you don't pay the stamp, then that unstamped document can land up into penalty in the court. So it is not the case that court will not, entertain that document, but their court can impose heavy penalty on you for not stamping that document in the beginning.
On the producer or the production house?
That depends upon what is written in the agreement. It is also should mention that who shall pay the stamp. Suppose it is written that a stamp shall be paid by the production house, then you can go with that agreement. Court will entertain. And if there is the document has not been stamped, then the production house shall be, fined and something. But suppose it is written that a stamp is, paid by both the parties, shared by both the parties, then you also have to stamp your document. And suppose nothing is written about the stamp, in that case, it is advisable that you should get your document stamped.
Right. Interesting. And what about, let's say, like when people are working, as you said, like they know each other and there's some familiarity. A lot of things are kind of agreements are made just on email, few lines on email or few points in email or WhatsApp. Are these legally admissible as well?
Very dangerous and very bad, I would say. One should avoid it because look, agreement is something which is a concluded discussion. For example, I offered you something and you have given your absolute unconditional acceptance to that offer. That is agreement. Okay. If you diluted it in any manner, that is not an agreement. So when you do something on the WhatsApp, and also another important thing that your intent should be that you are entering into something legally binding. For example, your husband offers you, tells you that, look, today I shall take you to the dinner. You say yes. He doesn't come and he doesn't take you to the dinner. Can you sue him for the breach of contract because he has given you an offer and you have accepted? But you cannot sue him for the breach of contract because there was not intention to enter into certain legally binding relationship. Similarly, when you just chat, okay, please write you will write the script for me. I shall pay you 5,000 something in the WhatsApp, very casual manner. There's no, implication. There's nothing finalized. It may not be, court may not see it as a legally, enforceable relationship. Similarly, on the email also, it is very tough to say it is a concluded discussion. For example, you offer your friend that, okay, you write a script for me or you act in my film. I shall give you 50,000 per day. Okay. This guy say, 50,000 is a lower amount. Give me 55,000. 55,000. Okay. And you also have to arrange my lodging and everything. And then discussion doesn't happen further. So this is not an agreement. No, you offered something, this person, and फिर आप लोग काम करने लगते हो. Let us say. There's no concluded agreement here. 50,000 मिलेगा या 55,000 मिलेगा, रहने को जगह मिलेगी या नहीं मिलेगी. These things have not been concluded. And also you will miss several things. You produce IPR. You say IPR shall belong to me. This doesn't happen like that. IPR shall belong to you for which territory? What is the geographical location? What is the time period? What is the term of your agreement? What is the nature, whether it is assignment or license? So you cannot do all those things on the email properly. But having said that, I would say that suppose you get certain, terms very clearly drafted by a lawyer, you can say, and if you have good understanding of law, and I'm not saying this इधर से ले लिया, copy paste कर लिया, वो सब चीजें तो बहुत ही dangerous है. If you really have a good understanding of law, or if you have taken a legal advice, and then you formulate certain basic understanding, you write and you send other person on email, and that person absolutely say that, okay, I accept it. In that case, you can say there is a kind of agreement, although there is no stamping done, there is no, all those formality of execution done, but still this is better than, that casual thing where you just send an email, there's no conclusion, just on the negotiation, just send a WhatsApp. Avoid those things. If you are entering into such a, important relationship, commercial relationship, why you won't get few days and why you don't get your paperwork done? You make it as a part of your work. Why it is so tough? You have a lot of things today on internet, like all the help is available. You can anytime seek for the help, and the help is one click away. So get some help and do the proper thing done. So that will be quite helpful.
So let's say now I've signed a contract with someone. I find in my experience, like something I signed a few years ago, they just started the contract with something which I found so off-putting. The terminology was that so and so, mentioning my name, is desirous of working on this project. Now, it's a very basic thing. I'm sure it's just a legal way of putting across something. But my question to them was that you approached me for work. I am not desirous. You have hired me for something. And I feel there is a difference there when you frame something like that. And they, of course, said, no, it's just legal jargon and all, which I didn't agree with. So I made them change that to that you are desirous of hiring me. So I feel that a lot of times, and this is a feedback that I've got from a lot of people, editors and other post-production people, that they find contracts very one-sided. And also, so that's one thing. The second thing is that it's a question really that one-sided agreements are apparently illegal. But we are facing a lot of, we are combating these on a daily basis. So are they illegal as such, or what is it exactly?
Okay, so I want to divide it. Like, I want to break down your question. First of all, you rightly said, there are a lot of problematic clauses in an agreement. Okay, you give the example of, they say that you are desirous of working. It does not have much of the legal implication, but there are much worse agreement. It should be like parties are desirous to work together. Like,
exactly.
So here I would say that stringent language in the contract sometimes creates, mental pressure on the party. That is one thing. So yes, contract language should be clear. It should be unambiguous. But at the same time, a contract drafter should avoid this stringent clauses. Okay, so that is good. That is okay. Now, secondly, there are a lot of clauses which are very bad in nature. For example, they say that a producer may give you the credit for the work done by you.
Yes.
This is problematic because then it gives them a discretion whether to give you or not give you the credit.
Exactly. Yes.
That is one thing. Secondly, they say that producer can anytime terminate the agreement by giving you the 15 days notice. So you have a lot of time. You said no to 5 projects and then you came to this project because you want certain job security. कि भाई मुझे काम करना है, अच्छा project है, पैसे भी मिल रहे हैं, मैं काम करूं. Then they make it so uncertain that they say कि producer can terminate the agreement anytime. So there is zero job security. Then consideration clause, they say that they shall give you 10 lakh rupees. But then the tranche is so bad. Like when suppose they say that once your work is done, you should keep getting payment. But they shall link a lot of payment to the release of the film. Or a lot of payment, to the satisfaction of the producer. When your work is the satisfaction of the producer.
Correct.
But they do not define that what is satisfaction of the producer.
What is that, and when are you okay, and what is, even with editors, for instance, I'll tell you, and I've experienced this myself, they'll say when the first cut of the film is ready, then we'll do the first cut. They'll say, no, but this is a lineup. So
Yes.
that terminology, who
Yeah.
decides?
So that is problem. So therefore, you should make the payment to the lineup as well. You should make the payment once I submit my work, certain portion,
Yeah,
and
yeah,
certain portion you can keep to the final cut. That is
yeah,
okay.
yeah.
But you cannot keep everything like that. I mean,
Mm.
this is the problematic. So all these clauses are very problematic. Now coming to very important part, you said your last part, that whether these kind of agreement are legal. So I yes, I mean, do not presume that these agreements are illegal.
Mm.
These are legally enforceable agreement. They have given you certain clause which is not good for you, but those
Mm.
clauses are good for them. Okay. Now,
Yeah.
secondly, you have proper chance to negotiate it. It is not a consumer agreement. जब हम वॉशिंग मशीन खरीदते हैं तो उसके साथ टर्म्स एंड
हाँ.
कंडीशन आता है. हम अगर वो वॉशिंग मशीन खरीदेंगे तो वो आएगा और कोई उसको पढ़ता भी नहीं है, छोटे छोटे लैंग्वेज में वो लिखे हुए
Correct.
होते हैं.
Yes.
ठीक है.
Yes.
तो उसमें अगर वो कुछ बहुत गलत टर्म डाल के देता है तो हम उसको बोल सकते हैं कि भाई तुमने अनफेयर ट्रेड प्रैक्टिसेस किया. उसी तरह सपोज हम कोई अपार्टमेंट खरीद रहे हैं तो बिल्डर्स का हमें एक टर्म्स एंड कंडीशन आता है, और अगर उस टर्म्स एंड कंडीशन को हम नहीं साइन करते हैं तो हम वो अपार्टमेंट नहीं खरीद सकते हैं. ओके. और वो बहुत स्टैंडर्ड टर्म्स एंड कंडीशन होता है. उसी तरह हम किसी वेबसाइट पे जाते हैं और उसके वेबसाइट पे भी रहता है बहुत सारे स्टैंडर्ड टर्म्स एंड कंडीशन व्हिच वी डू नॉट रीड एंड दैट इज वन साइडेड unilateral.
Yeah.
अगर उसमें सपोज कोई क्लॉज है which is very harmful to the person, okay, so in that case they can say कि okay, this was unfair trade practice or this is not legally enforceable. वहां पे हम ये argument ला सकते हैं. For that we need to convince the court. But you cannot say कि जो agreement आप दो equally two business people have signed together, they ample of chance to negotiate. They had ample of chance to say no if the negotiation doesn't work. तो अभी इसमें सिर्फ ये प्रिज्यूम करना, अच्छा अच्छा बुरा क्लॉज साइन करवा रहे हो, ये तो इन्फोर्सेबल होगा ही नहीं. आई मीन यू कैन नॉट लाइक दैट. So this is a myth which I want to say here, make you clear here, that you being a major, you being a service provider, if you sign an agreement which is bad, which has bad clauses, until and unless they have not put something illegal, something immoral, something which is not legally permissible, which is legally void, if they have not put that kind of clause, the agreement is very well binding, and you have to, like, they will be able to enforce the agreement against you. So you cannot say that it is non-enforceable.
Interesting. So for instance, one of the clauses which we find very one-sided is that they say ki, in case of any dispute, that dispute will be resolved by arbitration.
There are two ways to resolve a dispute broadly. One is the litigation, okay, and another is the alternative dispute resolution, okay. That is an alternate to go to the court, because sometimes court takes its own sweet time, and we know about the Indian judiciary, its backlog and everything. So you will not get a prompt resolution when you approach to the court. So therefore, to provide you a substitute, there is an alternative dispute resolution mechanism. It includes mediation. For example, something happens in the SWA where suppose two party has dispute, they come together. There's a dispute settlement committee. You can go there. They mediate. They are a bench of mediator. They mediate the dispute, and if you both agree, then okay, the dispute is resolved. Suppose you don't agree, they cannot enforce their opinion on you. Okay, so that is a mediation. Similarly, there is conciliation. And then thirdly, as you said, there is an arbitration. Arbitration is governed by Indian Arbitration Act 1996, and it is a very well legal mechanism. The Indian Arbitration Act 1996 is a very detailed document. There's a proper, like, how to appoint an arbitrator, who will be an arbitrator. There should not be any conflict. There should be proper hearing. Both the parties should appear before the arbitrator. You shall receive the equal chance to present your case and everything. And arbitration is a prompt mechanism as well, because they do not have a pendency of case. They are looking just at your case. Therefore, the chances of resolution increases. So I think that is not a bad clause.
Okay.
Arbitration clause is a good clause
to have. Okay. So actually preferable than having a clause which says it'll be resolved by the courts of India. That's another clause we come up with sometimes. So maybe that can be, if we see like a clause in our contract which says will be resolved by Court of India, we can say no, opt for arbitration instead.
Yes. So that is again your choice. There are two mediums. Both has its own pro and cons. For arbitration, the cost may go high because if you appoint arbitrator, you have to, you need to pay the arbitrator. It is not like you don't have to pay the judge, but you have to pay the arbitrator their fee. Then you have to pay all the money that involve in, having that bench. Suppose it happens in certain hotel or certain, conference hall, then whatever the cost of that conference hall comes, you need to pay that and everything. So this may be a bit costly affair. They provide you a good service, but then it may be a bit costly affair. So suppose if you are in a very starting of your career or something, and if you don't want to spend those money, then litigation is fine. So again, when this clause comes, then have the word with your lawyer, take the suggestion. This will tell you both the pro and cons, then decide that whether you want to go for a arbitration clause or litigation clause.
Right. Also wanted to know, so we have clauses which say that we can't go to, we have an editors union, but a lot of clauses say that we can't go to the union. Is this acceptable though?
This is a very bad clause to have in the agreement. Even I had a lot of problem with this clause whenever I, represent an artist to the producer or writer or actor, because each of them have their union and they have certain, faith that suppose some dispute arises, there is someone whom I can approach. Okay. And secondly, that producer does not have anything to lose here because they are not bound to go to the, go to the union. So even if you go to the union, producer can opt whether they want to go and resolve the dispute in the union or not. So then there is no point of having this, clause in the agreement and creating a lot of issues for the writer. So I guess that this is not a good clause, to have. People have that. But even if they have, in my opinion, I cannot prove it through any judicial precedent or something because there is none. Like approaching your union is your right?
Absolutely,
because, forming a union or approaching a union in a peaceful manner comes under Article 19 of the Constitution, in my opinion. So, if that is there, then they cannot take that from you. So you can approach to your union, try to raise objection when you see that kind of clause in the agreement. Tell them that this is not legally enforceable or a good clause to have. And even if you sign that, even then I think you can approach to the union.
That's what I was told.
Avoid signing such a clause. At least raise the objection that this clause is not a good clause, and you cannot take my basic rights from me. So that should be the argument.
Right. Also, since we spoke about sometime back, we spoke about termination clauses. In post-production, we have some really strange situations where we are not even given a notice period. We are just told that, okay, and not even reason. We are just told that you will be replaced. And the following day itself, the new person will come in. There's no NOC or a no objection certificate that we are signing. We are not given notice, as I said. A lot of times I find there's something that I fought about in one of my contracts. I was being asked to return whatever money I had received until then. So how does one navigate a situation like this?
Termination clause is a very important clause in the agreement. Generally, what happens, the artists see money clause tick, credit clause tick, let's go by this. But that is a very, myopic view to see an agreement. Termination, along with the consequence of termination. As you said that if the agreement is terminated, you need to refund all the money. That comes under the consequence of termination. So termination clause should be properly reviewed and it is like you should fight for any arbitrary termination that is there. If there is an arbitrary termination, then you must say, first of all, if suppose you are just a service provider, you have not you are not an IP creator or something, you are just a service provider. Even that case, no cause termination should not be welcome. You should fight for that because in the case of service provider, still I can say, okay, fine, jitna service maine diya, utne ka paisa mujhe mil jayega till the end and till the termination on the pro rata basis. Even ye सर्विस प्रोवाइडर के लिए भी आइडियल इसने नहीं है कि अगर आपको किसी ने 10 लाख रुपए प्रॉमिस किया है तो आप वो 10 लाख का व्यू लेकर के अग्रीमेंट को साइन करें। आपने ये नहीं सोचा है कि किसी भी स्टेज पर अग्रीमेंट टर्मिनेट हो जाएगा। सपोज 3 लाख का मैंने काम किया, 3 लाख का अग्रीमेंट टर्मिनेट हो गया और मुझे 3 लाख मिल गए, दैट इज ओके, बिकॉज यू हैव साइंड द अग्रीमेंट बाय लुकिंग एट दैट 10 lakh figure and you have said no to the several project which has that सपोज उसने 9 लाख ऑफर किया था पर आपको यहाँ पर 10 लाख मिला तो आपने उस प्रोजेक्ट को ना कहा। लेकिन अगर ये नो कॉस्ट टर्मिनेशन, दे कैन टर्मिनेट द अग्रीमेंट एट एनी स्टेज, तो 3 लाख 4 लाख जब हो रहा है पेमेंट उस समय में वो अग्रीमेंट टर्मिनेट कर देंगे, देन यू डोंट रिसीव द एंटायर पेमेंट। सो in the case of IP generator, suppose you are the generator of the IPR, in that case, so there should not be the termination clause at all. It means no cause termination clause. It is always like if you breach the agreement, if you do not perform, if you refuse to perform, in all those cases, I can understand that there should be a termination. But no cause termination should be like you should fight against that.
Yeah, like for post-production, it doesn't make any sense because as you said that we leave projects and then we come to this project with certain budgets and, putting in that kind of time. Right. Also, for instance, we are asked to work on, not asked to necessarily, but there is an expectation that we will work on Sundays, public holidays, and whenever it literally says, whenever the producer wants you to work. So you'll find editors are basically editors, assistant editors, associates, sound teams, VFX teams, they're working round the clock and 24/7, 365 days a year. So is there nothing legally that can protect us as freelancers that can protect us?
There's nothing legally. Even I'm working on the Sunday, like me being the lawyer, I work on the Sunday. Also, that is your choice now. So you may have to work on the Sundays as well, or you may have to work on the public holidays. Then it is your choice. If you don't want to work, then put that clause.
So that's up to our discretion, basically. Sure. But it can't be, again, because there, as you said, there's no legal framework. So it's up to how well we are able to negotiate that.
Negotiate the contract. Correct. So you can negotiate that, look, I shall work 12 hours maximum in a day. So you cannot call me midnight or something. I shall work in this duration only. I will not work at least like in one Sunday in 15 days. If you want to put certain, clause, you can put. But when you have to fight for the basic, then it is very tough to have this luxurious clause.
Exactly. That's very true. That's very true. And similarly, I suppose even if like a lot of times we are not even offered food, we are not offered in a lot of studios, not even basic things like clean washrooms and stuff. So that is also something that we have
that should be put in the agreement, because in the case of writer agreement or in the case of director agreement, even in the case of actor agreement, these clauses are deliberately put like that. You should provide me, standard house, hotel room, proper meal, 2 times meals, 3 times meals, whatever. So they put this clause in the agreement. And if you are a bigger writer, then they put about the vanity van as well, 4-star hotel, business class travel. So if those things can be put, then you can actually ask for the basic.
Frequently, we find that our final payments and our TDS has not been paid. And this is a question actually that has come from a lot of assistant editors and associate editors. What are the steps that they can take? Because they don't even really have the monetary power to hire legal help. So what is it that they can do if this happens?
Yeah, so you have remedy. If suppose they have deducted your TDS and haven't paid. So when you sign the agreement, you have agreement with you. Okay. On the agreement, you should also request your producer to put their PAN number. Okay. Suppose you have worked, there is an agreement to show that this is this exact amount. Suppose I am required to be paid 1 lakh, 10,000 has been deducted as a TDS. And they don't pay, then write an email to them, put some follow-up. Even if they don't pay, then you can directly complain to the tax authority. Okay. So you can take the help of lawyer for the detailed, step elaboration, like how you can do it. But there is a remedy. But you need to have the PAN of your producer, or you can say one who has hired you. So if you have that information, I think there is a remedy.
It should be easy enough. Finally, I just want to ask you, Anamika, that there is this force majeure clause that has come up, especially post-COVID, where they say that they can stop work. I mean, they have to probably stop all work during this period in case, let's say, there's a lockdown again or whatever. And anyone who they have hired, they will stop paying them for this period of time. So, as we've seen, it could be 1 month, it could be 6 months, it could be 8 months. Again, I suppose there is no way for us to negotiate through this.
So yes, again, negotiations should be like, suppose they are genuinely not able to work, or you are not able to work. The situation has become as bad as COVID-19 second wave. People were dying and everything. No one were able to work. And if you had all the, set up to work, you were not in your mental space to work. If work is not done, suppose they are not making you work due to the force majeure, which is not in the hand of any of us. So I think in that case, this is not a bad thing to have the force majeure clause, because you are also not working in that duration. Producer is not able to work in that duration. So that is fine. But whatever the payment that has accrued to you before the force majeure period has started, that payment should be cleared. That payment should not be withheld. You need to put that thing in your force majeure clause. And the moment the force majeure mitigates, the work should be resumed. Okay. It cannot be forever period, or it cannot be on the discretion of the producer that when they feel that force majeure has, ended. So there is a requirement of a bit tweaking in the force majeure clause to, protect your right. But having force majeure clause is not a bad thing
at all. Right. Great. Thank you so much, Anamika. This has been very, very helpful. And I'm hoping that whoever's watching will also, have found some idea of how to negotiate clauses. And I think if anyone wants to reach out to Anamika, I'm going to be linking her details in the description below. So please do reach out. This has been really, really great, Anamika. Thank you so much for the session.
Thank you so much. Thank you.
If you enjoyed this video, then please like it, share it, comment on it, and subscribe to this channel so you're tuned in for our upcoming episodes.